Partnership Act state rights and duties of a partner as ascertained by agreement or defined in Partnership Act may be varied by the consent of all the partners, either express or implied. Section 26 subsection A states all the partners are entitled to share equally in the capital and the profit of the business and must contribute equally toward the losses, whether of capital or otherwise sustained by the firm. If the capital contribution is unequal, this implies the existence of an agreement between the partners that their right to the share will be based the amount of their contribution. Subsection B states a partner has the right to claim indemnity from other partners in respect of payment made or the personal liabilities incurred by him, either in the ordinary or the proper conduct of the business of the firm, or when his action is necessary for preservation of the business or property of the firm.
In the case Ko Hong Leong versus Seo Ko Cheng.
This seems like a nice boat. I think we should rent it.
And so they enter into a contract to rent the boat. One day, the firm had breached the contract and was sued for a claim amounting to $4,246.50 as damages.
Oh no, the firm has been sued. It's okay, I will use my own money to defend the claim.
He succeeded in reducing the amount that should be paid by the firm. During the dissolution of the partnership, the court ordered that the legal costs incurred by the respondent is paid from the firm's asset. The appellant objected the order by filing an appeal to the appeal court. The court held that because the action by the respondent was in defending the claim was to preserve the firm's asset, he was entitled to be indemnified by the firm. The appeal was therefore dismissed.
Section 26, Subsection C of Partnership Act 1961. Advance or payment made by a partner. If a partner had made an advance or payment beyond the amount of capital which he has subscribed, he is entitled to interest of 8% per annum from the date of payment or advance. Section 26, Subsection D of Partnership Act 1961, Interest on Capital, it stated that before the settlement of net profit, partners are not entitled to payment of interest on capital. If a partner is not willing to contribute capital and without receiving interest, he should make payment of interest on capital and make express provision in the agreement. Section 36, Subsection E of Partnership Business 1961, Management of Business Partnership. It stated that every partners have right to involve in the management of the partnership business.
In the case of Irie versus Borham,
A and B are two partners who agreed to devote their full time to the partnership, but later they quarreled, and during the dissolution,
I should get extra remuneration because you left me to carry the business alone. No!
the court held that the partner who does extra work will get extra remuneration by the order of the court.
Section 26, Subsection F is about a partner is not entitled to the remuneration for taking part in a partnership business. However, in a partnership agreement, allowed an active partnership to take additional salary to his share of the profit. Subsection G states that no person may be introduced as a partner without consent of all existing partners.
In the case Brian versus Reed, in a meeting room.
Good morning. As for today's meeting, I would like to nominate my son as our new partner. I would like an approval from all of you.
No, this is nonsense. We will not agree on that nomination. Yes, that is the end. We have more important matters to discuss about.
The following days, the partner argued over the matter of nominating his son as partner, and they subsequently all came to an agreement to accept his son as partner and promised to fulfill anything necessary for his admission, but was found that the other partners had failed to do so. Thus, the son sued the partner. Court held that partners were bound by partnership deed. The son was partner upon nomination and therefore could exercise his right.
Section 26, subsection H is about any difference that arise to the ordinary matter that connected to the partnership business may be decided by majority of partner, but change may be not made without consent of all existing partner.
In the case Hailey versus Walker, in the meeting room.
Attending the meeting, I have important matter to discuss about. I have agreed with one of our partners to introduce a new partner into the business, which my son, for the purpose of the meeting.
What? Why all of a sudden you want to accept him into the partnership? I will not agree on his admission into the partnership. That is an order for both of you.
Later, the issue was brought to court over the injunction to prevent the admission of the partner's son. Court held that the injunction would not be granted since the difference between the partners was only an ordinary matter connected with the partnership business that could be decided by majority of the partners.
According to Section 26I of the Partnership Act, the partnership books are to be kept at the place of business, and every partner may, when he thinks fit, have an access to and inspect and copy them. This can be further explained in the case of the Bevan versus Webb, where the sleeping partners were denied of access of the partnership books by the managing partners.
In the case of Bevan versus Webb,
One day, the sleeping partner was about to enter into a contract to sell their interest to the managing partners.
I went to sell my interest to you, so I hired a valuer as my agent to inspect the funds book.
I disagree. The right to inspect the funds book should only be exercised by a partner personally.
so the sleeping partner applied for injunction to compel the managing partners to allow the valuer to have access to the books. Court held that the right of inspection could be delegated to an agent as long as there was no reason to object to him.
Section 27 of the Partnership Act states that majority of partners cannot expel any partners unless such power has been conferred by express agreement between the parties. However, if a partnership agreement provides that a partner may be expelled for a breach of certain specified articles, other partners can only exercise the power in good faith.
In the case Green versus Howard, in the office meeting room.
This is embarrassing. I have full evidence of our partner had misconduct. I'll call you to this meeting to agree with the evidence and support me in making notice of his expulsion.
Looking at the evidence, I can see that the misconduct is legitimate. We do have provision to expel another partner who is in obvious breach of his duty. It can be done and I will support you.
The two partners later called upon the other partner in a meeting and served the notice of expulsion in good faith. Court held that the notice was in good faith, majority agreed and expressly noticed the other partner. Thus, the notice was valid.
According to Section 30 of the Partnership Act, partners are bound to render true accounts and full information of all things affecting the partnership to any partner or his legal representative.
the case of law versus law.
Sell to you my share for £21,000. Alright. Wait a minute. You did not disclose the partnership asset consists of the interest. I demand the contract to be set aside.
Okay. I will make the settlement. It better not to bring this to court.
Unauthorized personal profit. Section 31 states every partner must account to the firm any benefit derived by him without the consent of the other partners from any transactions concerning the partnership. Partner must not make a profit for himself by making use of his position as a partner or by using information obtained in the partnership business without other partners' knowledge and consent, for example, secret profit. Of duty and interest. Section 32 states, if one partner without the consent of the other partner carries on any business of the same nature as and competing with that of the firm, he must account for and pay over to the firm all the profits made by him in that business. This section contains two conditions. First, the business of the same nature and competing with the partnership business. Second, the competing business carried on without the consent of partners.
In the case Bentley versus Craven, in the office.
Thank you for accepting my call. Sure, you are welcome, no worries. Yeah, as you can see, I would like to buy an amount of sugar from our firm. Sure, bro. You are one of our partners and you will get discount price from the purchase.
The partners later agreed on the agreement that the partner purchased an amount of sugar from the firm. Later, it was found that the partner had sold the sugar back at the market price without making notice to his other partners. The other partners later found out about the undisclosed profit and claimed the profit made by the partner that sold the sugar at the market price. Court held that the partners were able to claim the profit as the held accountable partner were making profit without the consent of other partners. Referring back to the case Bentley versus Craven, it is also applied to Section 32 as the held accountable partner were making profit from selling product that is in the same nature of the business, which also without the consent of other partner.